All right. Okay, we are back in session. Our final case today is American Home. And is it pronounced SIBO?
Yes, Your Honor.
Okay. Write down. Okay. Attorney Besvinik, how much time did you wish to reserve for rebuttal?
5 minutes, Your Honor.
5 minutes? Okay. I will try not to disturb your presentation and at the same time to let you know when we get there so that you know.
Thank you very much.
And you can adjust.
Thank you.
You may begin, counsel.
Thank you. Thank you, Your Honor. My name is Laura Besvinik, may it please the court, and I'm representing the petitioner American Home Assurance Company. This is a first-party bad faith action. It's been before this court before, arising out of a homeowner's claim. Mr. SIBO was the homeowner.
All the way to the Supreme Court, too.
It did indeed, and came back. And it came back. It went back to the trial court. There were years of proceedings, follow-on proceedings in the trial court, and we are now in the first-party bad faith claim. And Mr. SIBO, having collected approximately $21 million so far from American Home and other third parties on his $11.2 million home, is seeking an additional $20 million in compensatory damages now and punitive damages. The issue on this certiorari petition, for Your Honor, is very specific. The trial court required that American Home produce work product documents maintained not in its files, but in the files of its outside lawyers. And as Your Honor noted, this case has been in litigation for a very long time. The claim was made in 2005. American Home initially partially denied coverage in 2006. Additional documentation was submitted in 2008. It reiterated its coverage determination at that time. At that point, there was no litigation pending. There weren't lawyers involved. The lawsuit was filed by Mr. SIBO. Mr. SIBO added American Home to the lawsuit in 2009, having previously sued all of the contractors and the seller of the home. They were added in 2009, and that's when lawyers get involved. And those are the documents that we're talking about. They're the work product documents in the files of the trial lawyers that represented American Home in the litigation, of the appellate lawyers that represented American Home in this court, of the appellate lawyers that represented American Home in the Supreme Court, and in the work files of the lawyers that represented American Home on remand. Those are the documents that we're talking about. The trial court, accepting the argument made by Mr. SIBO, essentially applied the Supreme Court's decision in Allstate versus Ruiz as a bright line and said, in Allstate, the Supreme Court said that work product documents prior to the time the final judgment is issued are fair game in a first party bad faith case, and they have to be produced. Now, Allstate dealt with the claim and litigation file of the insurance company. And I want to be clear, the files of the insurance company have been produced. The subject to the assertion of the attorney-client privilege, which the Supreme Court reaffirmed in the Genovese case 6 years after Allstate, and said insurance companies still have their attorney-client privilege. That is protected and remains sacred, that we protect the attorney-client privilege. It's not waived simply by the fact that the insurance company is a litigant now and is being sued for bad faith. So this case involves this question of whether the work product documents in the files of the outside counsel during lengthy litigation and litigation that occurs after those coverage decisions have been made by the insurance company, whether the act of that insurance company defending itself, whether the first party bad faith plaintiff should necessarily be entitled to those documents. And it's our submission to the court and to the trial court that they do not meet the test for obtaining access to these work product documents, which, and I think this is important, this is the work product of lawyers defending their client in litigation. This is core opinion work product. We're not talking about the investigation of the claim that led up to the determination by American Home to reach the coverage determination that it did in terms of factual investigation of the loss at the home, things like that. This is core opinion work product of the lawyers representing the insurance company as a litigant in litigation, having been sued by its insured. Now, in Genovese, the Supreme Court looked at its prior holding in Allstate and explained that what it was doing in Allstate was applying the work product rule now codified at 1.280B4, in which the rule states clearly that for regular work product, there has to be a demonstrated showing of need and a substantial hardship. Now, applying that rule here to the documents in the files of outside counsel, SIBO does not meet that standard. There are a number of reasons. First, I want to be clear, Mr. SIBO in his answer brief and in the court below cited a number of cases applying Allstate versus Ruiz. None of them involved this circumstance. None of them involved the work product documents of lawyers, in this case, multiple lawyers, the Butler firm, White and Case, Bohm Brown, all of these lawyers over a 9-year period of defending American Home. None of those cases involve that. Now, why does that matter? Why is that difference significant? It goes to the need question. The rationale of Allstate, and is recognized in Genovese, is that it is all need driven. Why do they need these information? The question was, how do we understand how the insurance company adjusted the claim, made its coverage determination if we can't see the claim file? Well, that claim file is produced. The question is, how do we know what they did in the litigation? Well, they have 9 years of litigation. In this circumstance, American Home has not invoked advice of counsel as an affirmative defense. What it has said is, our position is right there for everyone to see. It's in the thousands of pleadings and briefs and motions and court hearings that comprise the record. That's our position. That was our coverage position. That was our thought process. There it is. It's all there in the papers. And contrary to the assertion in the answer brief before this court, lots of documents have been produced. Tens of thousands of documents have been produced. The documents that were not withheld as work product and the documents that were not withheld on attorney-client privilege grounds were all produced. It's the stuff of the litigation. And the files of the insurance company handling the SIBO claim have also been produced. All of that tells the story of how the claim was handled. And American Home in the bad faith case will rise or fall on that record. It did what it did. It had reasons for doing what it did. And it says set forth in the record that has been provided to Mr. SIBO's counsel. The opinion work product, which is this court has recognized in the Tedrow case, is absolutely or nearly absolutely privileged. Those documents are not anything that Mr. SIBO demonstrated a need for or has a need for in order to present his bad faith case against American Home. And there are real problems created by the expansiveness of requiring the documents that are actually in the lawyer's files to be produced, because it creates a tension between the Allstate holding, which says a plaintiff needs to be able to understand the claim file in order to bring its bad faith claim, which makes complete sense, but preserves the attorney-client privilege. Because if we are to go in and raid the files of the lawyers who are representing their client, the insurance company, in litigation, at trial, on appeal, in this court, in the Supreme Court, requiring all of those documents to be produced would invade the attorney-client privilege, because that work product, that core opinion work product of the lawyers, is presumably the basis for the communications that lawyer will then have with the client. This is respectfully an end around on the rule in Genovese that the attorney-client privilege remains intact for insurance companies. Just because you're an insurance company doesn't mean you're not entitled to have a lawyer and to defend yourself. Now, it also relates, Your Honors, to the litigation privilege, which is the Supreme Court has recognized that litigants are entitled to defend themselves. That's privileged conduct. Again, we're not here on the litigation privilege. That is not a discovery privilege. That's a substantive privilege, but it goes to the need element. There is no need for these documents, and that is still the requirement. Allstate is not, as Mr. Sebo has argued, a categorical rule. It is a special instance of an application of Rule 1.280B4, which continues to apply, which is what Genovese made clear. The cases cited by Mr. Sebo largely predate Genovese, often treat Allstate as a categorical rule. They are not from the Florida Supreme Court. And they do not involve, as this case does, this wholesale imposition into the files of the lawyers that are representing the insurance company in litigation. Now, this case is different from most cases in that regard, because a substantial portion of the life of this case was spent in litigation through just the timing of trial and the appellate procedures and how appellate procedures work. Because there was the time spent going up to the Supreme Court, in the Supreme Court, and a decision being reached, and issues being sent back to the trial court on remand. So, Your Honors, for these reasons, we would ask the court to vacate the order of the trial court requiring this production of all of these attorney-client privilege, these work product documents and these opinion work product documents in the files of American Homes outside counsel. So if the court has no questions, I will wait for my rebuttal.
Doesn't appear there are questions at this point. Okay, then we will save for rebuttal. Let me clear the time. Mr. Weaver, I believe it is your opportunity to respond.
Thank you, Your Honor. Good morning, and may it please the court. My name is Matt Weaver. I represent the respondent in this case, Mr. John Robert Sebo. Before addressing some of the points that my opponent made, I want to start with what we contend is really the key issue and the key case that this court needs to consider in dealing with this petition, and that is the Ruiz case. American Home talks very little about it in its brief, and Ms. Besvinick talked very little about it today, but it's very important, both from understanding the posture of Ruiz and how the issue arose, and from understanding the history of work product immunity in bad faith cases in Florida. Now, before Ruiz, you had a situation where courts were treating work product immunity differently depending on the type of claim that was being raised. The court in Ruiz talks about this, and they cite a case from the 3rd District called Stone, which was a third-party common law bad faith case from the 1970s. And the court made the point that in those cases, courts have consistently said that there is no such thing as work product immunity based upon the needs of those cases. And that makes perfect sense in the third-party liability context. There you're talking about the existence of an excess judgment arguably caused by the insurance company's conduct. Now, Ruiz noted that in the first-party context, which, as this court is aware, for the first-party bad faith remedy is a creature of statute in Florida and didn't exist until 1982. But in the first-party context, there had been inconsistent application of this rule. And the Ruiz court sought to figure out that issue and settle it. And they started by looking at the duty that the statute 624155 imposed and that the legislature chose to impose on insurance companies. And they said this, I think this is very important. The legislature has clearly chosen to impose on insurance companies a duty to use good faith and fair dealing in processing and litigating the claims of their own insureds. Now, why is that important? Well, you heard Ms. Besvinick talk, and American Home does this in their brief, talk about this right to have lawyers represent a litigant in litigation. Mr. Sebo doesn't quibble with that right. But what's sort of swept under the rug by that point is that there's a duty on behalf of American Home to treat Mr. Sebo with good faith in litigation. And for better or worse, that duty extends to the lawyers representing American Home. The court in Ruiz noted that a contrary rule would essentially hamper the viability of the first party cause of action and even thwart legislative intent. Now, turning to the actual issue in that case as to whether work product was discoverable, again, the court uses phraseology that goes to this showing of need issue. And the court says, claims file materials presents the virtually the only source of direct evidence with regard to the essential issue of the insurance company's handling of the insured's claim. Now, again, we know from many cases, multiple Florida Supreme Court cases, that the focus in these cases is on the actions of the insurance company. And a jury gets to evaluate the totality of the circumstances bearing on the insurance company's conduct. So for Ms. Besvinick and American Home to argue that, well, we stand on our papers and we stand on the pleadings we filed and the arguments we made in the trial court, in the various appellate courts that saw this case, it's really just, it's trying to prevent Mr. Sebo and the jury from understanding the totality of American Home's conduct. Because American Home's conduct extends beyond what their lawyers actually did in litigation, the positions they took. The real issue here, and I think this is something that American Home sort of glosses over, the real issue is how to define claim handling. Does the claim handling end when litigation starts? That's the issue. If the answer to that question is no, and the Ruiz court has said the answer to that question is no, then I think this is a fairly easy case for this court to determine. Now, I want to talk a little bit about what happened after Ruiz. After Ruiz, you had this issue of, one, is Ruiz applicable in federal court? And there were a series of federal court cases that deal with this, and we cite them in our papers, cases such as Cozort, Wilson, those types of cases. And does Ruiz do anything to affect the availability of an insurance company's attorney-client privilege? And it was that latter issue that was answered by the court in Genovese. The court in Genovese actually reiterated its holding in Ruiz as to work product and spoke again in terms of need. And I'll quote again, the underlying claim materials are the evidence needed to determine whether an insurer acted in bad faith. And the court there talked about Ruiz in very simple, plain terms. In Ruiz, we held that in first-party bad faith actions brought pursuant to section 624155, work product materials were discoverable. Now, another interesting thing about Genovese, and we discussed this in our papers, it deals with the issue of opinion work product. And I want to remind the court of its standard of review on a petition for writ of cert. One of the things that American Home has to show is a departure from the essential requirements of law. I would submit to you there's only one case post-Ruiz in state court that directly addresses this issue of core work product. And that is the fourth DCA's opinion in Genovese. In that case, the insurer in Genovese made the exact argument that American Home is making here, that there's got to be some distinction between core work product and regular work product. The fourth DCA rejected that notion very clearly. And the real difficulty in terms of where the law sits in discovery in these cases deals with an issue that the Genovese court left open, which is, how do we find waiver? Is it possible for an insurance company, by their positions in a bad faith case, to waive the attorney-client privilege? We're not dealing with that issue here. And that's an issue that's going to be dealt with in the trial court in this case.
Well, can I ask you a question? Because I want to make sure I'm understanding one thing. in the general magistrate's order, there's a mechanism for an in-camera inspection
Yes.
on outside counsel alleged work product. Is that correct?
The scope of the order, Judge, is that she is inspecting attorney-client materials and things that have been withheld or redacted on an attorney-client basis. Her order does not go to the in-camera issue on work product. And just for the court's information, that inspection is actually ongoing. It's been ongoing for a while. We don't yet have an order on that issue.
Okay, thank you.
The only, looking at the magistrate's order, the only matter that was outright granted without an in-camera or a denial was the work product, pre-final judgment work product. That's all we're dealing with. Is that right?
That's correct, Your Honor. And I believe that the temporal limitation.
And just so I'm clear on the distinction, to you, that means you're entitled to the outside counsel's work product?
Yes, up until the point of the amended final judgment, which occurred in November of 2018, we have explicitly not sought. There may be some confusion in the record on this because of our briefs initially.
What is the source of that? Would that be, are you actually trying to get the documents that are in the attorney's files?
It would be attorney work product and American
When
Homes.
I read work product, I didn't necessarily interpret that to mean attorney-client because she's got a lot of other entries for in-camera inspections when it comes to attorneys. So I'm just trying to make sure you're claiming the entitlement to attorneys' file, outside counsel's file materials.
Absent any type of attorney-client communication that would exist between American Homes lawyers and American Home.
So in practice, how would that look? They would be entitled to assert a privilege, and then it would go in camera to determine whether it met attorney-client or whether it was discoverable?
Correct. And just to give an example,
Okay.
you know, in theory, you could have a situation where you have the attorneys drafting a piece of work product, call it an internal memo. And that memo may or may not be transmitted to the client. And it's the transmission of that to the client that's going to be something that the court has to look at for the in-camera review. But our contention is the memo itself is classic work product. So that's an issue that the general magistrate is currently dealing with.
Because frankly, I read Ruiz a couple times, and I didn't necessarily glean from Ruiz that we were talking about attorneys' files. I thought it was more geared towards claim files and the things that are in the insurance company's claim, which I understand. And granted, Ruiz is pretty sweeping in its verbiage to allow the discovery of that type of material. But I think Genovese makes it clear that, look, we still have an attorney-client privilege here. This isn't completely open season.
And Your Honor, I would agree with that reading of Genovese. I think the distinction that American Home is trying to draw that isn't really supported by the case law is that there's some difference between a, quote, claim file, unquote, and the documents at issue here. I don't believe there is. You essentially have a situation where for, gosh, almost 9 years from the time that American Home was sued in 2009 to the time the final judgment was paid in 2018, this case was being driven by American Home's lawyers. And Ruiz and other cases suggest that that's not something an insurance company can do and still avoid the production of that lawyer's work product. Our position is that essentially for purposes of work product, that there's no difference between the actions of the lawyers and the actions of the insurance company.
Okay, that's pretty broad.
I agree. And I think it's a creature of the language in Ruiz and other cases about the scope of the duty under the statute. And I want to pivot briefly to the specific need that American Home argues that Mr. Sebo cannot meet. Going back to Ruiz again, there was no showing of need in the trial court in Ruiz, and the court still ordered those documents produced. But specifically to the issue.
In Ruiz, the court doesn't use the word need, but the tenor of the opinion indicates to me that what they're saying is, look, there's no other way to mount a bad faith claim than by production of these documents. And in that sense, they are needed. It doesn't, again, I looked up and down to see if the word need appears, and it does not.
And I agree, Your Honor. It does appear in Genovese, however.
Right.
And I think that's important. And every court to look at this issue, both state and federal, have found that it is essentially a categorical rule when it comes to need. The fifth DCA in a case that we cite called State Farm versus Marisculio in dicta talks about this. It is dicta, that is a coverage case, I grant you.
So if you send a discovery request to an insurance company and saying we want work product consistent with Ruiz, then is it incumbent upon, how would that play out? Would the attorney then look through his file and decide whether he wants to claim a privilege? Is that what would happen next?
Essentially,
It would have
yes.
to be ruled.
Essentially, yes.
So you want all the attorney's materials that they've used over the last 9 years, and it would be incumbent upon the attorneys to say, no, you can't have this, or you can have this, and this is work product, but this is attorney-client, and this is a sheep, and this is a goat, et cetera, et cetera.
I think the process would be similar to what American Home did here. There would need to be a privilege log setting forth attorney-client privileged and work product information.
So they've indicated they've given you thousands of documents. What is it that you have not received that you think is covered by this order?
We have nothing internal to American Home that involves an attorney, whether or not that's a communication or not. And we have nothing in the lawyer's files that involves their work product. So examples, handwritten notes about their thoughts on certain legal issues, memoranda they might have drafted that are internal. We do have, and this is not in the record, unfortunately, I apologize for that. American Home did produce certain unredacted fee statements in the attorney's fee litigation that occurred in the coverage case. We have some of that. It hints at certain issues that we like to explore further, but we don't have the actual work product from those attorney files. And I just want to address, again, the need in what it actually means in this case. I mentioned earlier that the statute extends to an insurance company's duty in litigation. By the way, all of American Home's witnesses agree with that. And there's statutory language that is important. The statute speaks about what an insurance company could have or should have done had it acted with due regard for the insured's interest. I submit that these work product materials go directly to what the insurance company could have done. For example, if their lawyers are thinking of things that could have done, positions that could have been taken, it goes straight to that. It also goes to the issue of what they should have done. Now, the should have issue typically gets dealt with by experts, but it's not the only way it gets dealt with in this case. So you're talking about direct evidence of could have or should have. The other main issue here is the weight of legal authority, and this comes from the Supreme Court's opinion in State Farm versus LaFerre. One of the totality of the circumstances that the jury gets to consider in these cases is the weight of legal authority bearing on the coverage issues that drove the insurance company's decision making. So here we have a couple. We have the concurrent cause issue and the efficient proximate cause issue, which were the subject of the appeals before this court and the Florida Supreme Court. We also have other issues of set-off, post-judgment set-off that were litigated after the case came back down to the trial court. Now, I submit again that documents and things in the attorney's files that are not necessarily attorney-client privilege, but would be work product, go straight to these issues. We have an example already, again, in what was produced in the fee litigation that talks about the recognition of the concurrent cause doctrine as being the rule in Florida. It's just one example, but there are certainly others contained in the files. Just a brief issue about litigation privilege. Ms. Besnick's correct, and Magistrate Judge Pizzo in a case called MI Windows that we cite in our papers, I think correctly said that litigation privilege, litigation immunity is not a bar to discovery. It's a guidepost to determining relevancy. Again, I would point this court back to a series of cases that essentially say that privilege does not apply in bad faith cases. Ruiz is one, Burgess is another. The Supreme Court's opinion in Dayland Depot, which came out after Ruiz, is another. If the court is interested, and I submit that it's not necessary to resolve that issue for purposes of this petition, Judge Altanaga's discussion of this in the Kaffe case, which we cite in our papers, I think is very instructive. The bottom line is here we're on a discovery issue, and we're going to have summary judgment arguments. American Home has asserted the litigation privilege as an affirmative defense. Those are issues for trial, not today. Unless the court has any other questions, we ask that this court dismiss the petition. Thank you.
Thank you, counsel. We are ready for rebuttal, counsel.
Thank you, Your Honor. I want to address 2 points. To Judge Black, I want to be very clear about what the magistrate judge ordered and that the trial judge ordered. The only thing that were ordered in camera review are attorney-client privilege documents that are on an attorney-client privilege log. In the work product documents that may well impinge the attorney-client privilege, if required to be produced, they are not subject. The documents that are the subject of this appeal are not subject to in-camera review at this time. The court applied a bright line categorical rule based on Allstate versus Ruiz to the documents in the lawyer's files. If it wasn't an attorney-client communication, it had to be produced under this work product, this absolute work product rule, even though what we are talking about are thousands of documents, all of the work of multiple lawyers for 9 years. So I want to be very clear about the scope of the in-camera review. These documents that are the subject, and I think Judge Valente asked the same question, there is no issue with respect to the in-camera review of these documents. If this court were to affirm the order, I believe that my adversary would say that I would get a phone call the next day saying, where's the download of the documents? This is not, I do not believe that these are, in their view, subject to in-camera review.
Let me ask you a question before you depart, or
Yes,
before
Your
my question departs me, maybe better precisely. This comes up on cert is the argument made by Mr. Weaver. And there has to be a clear departure from the essential requirements of law. Although not specifically articulated, it was kind of alluded to. And there's only one case in here and out there, and it doesn't really get here. So if that's the case, is that prong met? Does, if we say here, we turn you down, arguably, do you not have the issue for direct appeal?
Well, I would say 2 things, Your Honor. I believe that the ruling of the court is a departure from the essential requirement of law.
You're saying if I do apply that one case, it's going to be a clear answer. I don't have to extrapolate. It's not a variation on a theme or anything like that.
I believe that requiring documents to be produced under these circumstances violates Genovese. That the
So if the magistrate would have recommended.
Privilege. Sorry?
No, go ahead. I'm sorry. Go ahead.
I'm sorry, Your Honor. I apologize with the back and forth. It's hard sometimes.
No. We're on this crazy Zoom, so don't worry.
So,
right
so what I would say is 2 things, Your Honor. I would say Allstate versus Ruiz did not require this result from the trial court. And there is no case that has been cited by Mr. Sebo that applies that rule of Allstate to the documents maintained in the lawyer's files. None. We cited a case, Your Honor, the Goldstein case, in which the court said, look, if it's in the lawyer's files, but it wasn't communicated to the insurance company, who's the one making the decisions, then it's not relevant. And by definition, if it's not relevant, you don't have a need for it. Because if it's in the lawyer's files, but it's not communicated to the insurance company, and the insurance company is the one that is making coverage determinations. And I think this is very important because I wrote down what Mr. Weaver said. And what he said was, we believe that the insurance company has a duty to treat the insured in good faith, and that extends to the lawyers representing the insurance company. And that is at the heart of the issue here, which is Mr. Sebo's theory is that the lawyer representing American Home owes a duty to the party that is suing American Home. That's what he said. And so the argument is, if the lawyers are doing research and they have research in their file, even if it's just in their file and it's not communicated to the insurance company, that's what they said they saw hints of in the bills. That's what they want to ask about. Here's why they don't have a need for that, and why this is so critical, which is American Home has not asserted advice of counsel as a defense. It has not waived its attorney-client privilege. And to Judge Casanueva's question, this is why this is an essential departure from Genovese. Genovese says the attorney-client privilege is intact. It serves a completely different purpose from work product. Work product is about a litigant's need. Attorney-client is about the thing at the heart of our system, which is the ability of a client and a lawyer to communicate, and a client to defend itself in court and have a lawyer to defend it. We have to have lawyers. We're a corporation. We can't appear pro se. We have to have that communication. Lawyers represent us. And we were sued by the insured. We have no choice in that matter. So
before I tell you your time has expired, I'm going to take my prerogative as Center Chair to propound one more question. Earlier, you made the contention or the argument that some of these work product documents, I think the word you used was impinged on attorney-client privilege. Had the magistrate and the trial court's order said that you could assert a privilege there for in-camera inspection when it impinged, would that alleviate your concerns?
I need to think about that, Your Honor. I don't think that it does, and this is why. Lawyers create drafts. They have drafts in their files. And at the end of the day, they may send that draft to the client, and the client will communicate back comments on that draft. Those presumably are attorney-client communications. If the lawyer is writes a memo to his file about research that he did, and then that research eventually finds its way into a brief, it's the final product that expresses the insurance company's position. That's what gets filed with the court. The work product, and the reason I say it impinges the attorney-client privilege, is that versions of what the lawyer is doing in his file is the basis for legal advice. And I say this because, and this is why I make the opinion work product point, this isn't about investigation of facts or whether the roof was leaking or whether, the windows were leaking, and we hire an expert or we send an adjuster out and that adjuster does a report, and that's work product. All that stuff is produced. This is the core stuff of the defense of litigation of a lawsuit, the preparation of appellate briefs, and those positions. And the one last point I wanted to make about Mr. Weaver's argument is this. At the end of the day, it's the insurance company that decides what its position is. It has lawyers and it's represented in court, but at the end of the day, that decision is the insurance company's decision, and that's who's on trial. That's who's on trial here, not the lawyers.
Thank you both for your insight into the issues presented in this case. It was very much appreciated and well argued. Please stay well. Hopefully we'll get to see each other again in the future.
Thank you.
That will thank you.
Yeah.
Now, I believe according to the world of long distance oral argument, I need to announce that the court is now adjourned. And I guess you exit. I exit, we all exit. Thank